for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Last week, they did jury selection. And, when you do the jury selection, the attorneys expect that people are going to be honest in the questionnaires. They're going to answer truthfully. And if the jury, either side or the judge, during the case of pendency of a trial, finds out that some of the jurors, a juror may have not been truthful in how they approached a case or how they answered their questionnaires, those jurors can be removed from that case. That's why they have alternate jurors. And I believe in this case there are 3 alternate jurors waiting to fill a spot if somebody is booted. Well, in the Weinstein case, they went through jury selection, and they showed up to start the case to have opening statements done by the prosecution and by the defense. And lo and behold, when they were out the night before or over the weekend, the defense became aware that one of the jurors, known as juror number 11, it's a female, is actually a novelist who has an upcoming book about predatory older men. And obviously the defense believed, wait a minute, she didn't mention that at all in the questionnaire. She didn't mention that when we were talking to her, and she should be bounced from the jury. She shouldn't sit on the jury for 2 reasons. One, because she wasn't truthful in the questionnaire and answering the questions. And 2, if she's writing a book, she is going to bring a certain amount of prejudice to the proceedings. That would be their argument. And she should be removed. And the prosecution obviously said, no, she should stay on. It's okay. And the judge, Fred, the judge agreed to keep the person on the jury.
I was shocked. So what it is a judge, there's 2 types of challenges. There's for cause and preemptory. So you only get so many preemptory charges. We've talked about that.
Yes.
It's 10 to 20 in New York. This is a New York case, and we don't know if it's 10 or 20. They've already got their preemptory charges. That means ones that they just kick off for no specific reason. They're not supposed to say why, but they just kick them off unless there's an issue there. But for cause is something that's very clear. But it is really judicial. It's a very a strong leaning toward the judge's discretion on whether or not they're removed for cause. Because what the judge can argue is, well, you could have removed them for not for cause, but for as a preemptory. But the argument on the defense is, but we didn't know this. They weren't completely forthright.
Absolutely. The exercise of the peremptory challenges occurs during the normal jury selection. This all took place after jury selection was wrapped up, and they found out about this. And look, the challenges for cause are if there is a reason to believe that that person cannot be fair and impartial. When I do a trial, it's usually people that say, look, I got friends who are cops, and I could never agree with the defense because, I have friends in law enforcement. Well, that would be a challenge for cause. They're being truthful that they couldn't be fair and impartial. If somebody thinks that they've already made up their mind. Now, if the defense was not able to show that this person, because she's writing a book, could not be fair and impartial, they may have an issue they may not be able to show that she should be excluded for cause. But if they can show, and I'm surprised that they were not able to, or the judge didn't agree with it, if they argued that this person was dishonest on the questionnaire, it was not truthful during jury selection, then that should be a cause challenge all itself. It doesn't matter if she says she can be fair and impartial. She lied. That would be the argument.
Yeah, you know what's interesting about that, though, Todd, is And this is the thing I just kind of wondered. So when you choose your jury, you have alternates.
Yes.
So if the judge says, well, I don't want to just get this, I want to keep the process going, of course it's going to keep going. You know why it's going to keep going? Because you got an alternate. Choose one of your alternates. And I doubt, I got to look, I can't remember.
I think they have three alternates.
Yes, usually you have two, but they probably have three alternates. boot that person off and use an alternate. And by the way, the alternates are actually sitting there just like a normal juror, and they've heard the case.
That's right. When they call all the jurors to come in, 15 jurors right now walk in and sit down. Only 12 are the active jurors, but the other 3 are listening to the evidence. I'm wondering if the judge is concerned that given the number of mistrials, because the defense moved for a mistrial here based upon the arguments they made with regard to juror number 11. And the court denied it. But if the defense moves for a mistrial, the judge may be concerned that the defense is going to try to start ticking off these jurors. And what happens when you run out of alternates and now you're down to 12 jurors are left, right? You got 12. You've already used your 3 alternates. And one of those jurors then does something where they should be booted. Well, guess what? That's a mistrial. You got to start all over again.
Well, and not only that, I think that it's going to come down to also, Todd, that there may be an issue of they're setting something up for an appeal. Don't forget, lawyers will set up, okay, I'm going to set this up for an appeal later if we lose this case. And I think that may be an appealable issue. I'm not saying they would win on appeal, but it's something they could argue in appeal.
Oh, come on. No points for you.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penney.
So, again, we always say without Weinstein or without maybe Avenatti, without Johnny Depp, without a bunch of these individuals, we wouldn't have anything to talk about. Johnny Depp, by the way, I like Johnny Depp, but it just seems like there's always lawsuits going on with or without Johnny Depp. But we're saying with Weinstein, there's always something going on. And I like this unto the O.J. trial. Those of you who are over 40, you remember the O.J. trial going on. I was a lawyer and a very busy lawyer at the time, and people were going, you know what's going on with the O.J. trial? No, I'm too busy in trial to deal with that. But now that I'm older and I'm the managing partner of a firm, I'm able to take some time and do the radio show. So I do follow these things, and we're following Weinstein, what's going on. So we just finished up talking about this juror that Todd says wrote this book. It is so interesting why the judge didn't kick this juror off for cause. Call us at 855-LAW-RADIO if you have a question about it, or tweet us at Radio Law Talk. Or, by the way, I always forget to say this. Email us at info@radiolawtalk.com, info@radiolawtalk.com. We get a lot of emails during the week for people who listen to our podcast later on. So, Todd, you had a point.
Yeah, just to follow up, to finish up with about this juror. As a prosecutor, it's very easy to think, well, okay, we won that motion, we kept the juror, we won here. Prosecutors have to be very careful having the I have to win mindset. Technically, my opinion is that in a jury trial, nobody wins anything. If the defense prevails, all the defense really won, if you will, is, hey, I get to continue to enjoy the presumption of innocence as it relates to that act. And if the prosecution wins, what they've really won is the ability to remove that constitutional right from somebody, and then they're sentenced. It's not like a civil trial where the winner gets a pot of money or they receive the check. It's very different. And if prosecutors get too much into this mindset of I have to win, they'll lose the idea in this particular instance that this great victory you think you might have as it relates to this jury could very well be the basis for undoing all of your work if an appellate court decides that person should not have sat on the jury.
Yeah.
In my opinion, this early on in the case, it would have been much cleaner to say, you know what? I'd rather err on the side of caution. Let's get a new juror in there. At that time, there had been no opening statement, no evidence presented, nothing. It was the perfect time to take one of the alternates and sit him in there and let this person go. But they didn't. And now you run the risk, if you're the prosecutor, of having it all undone if you get a conviction and a later court says, yeah, that was error. That person should have been bounced.
Let's talk about the first witness. The first witness, okay, Todd knows more about, the who's who of Hollywood. He's a Hollywood boy. He's down there. He goes to, actually you went to the Academy Awards of the young actors.
Yes, it was the Young Actor Awards ceremony. This is back in in May. And all these people in there winning awards for.
Did you win anything?
No, I was too old. I was too old. However, I was a lot of stage moms. A lot of stage moms there. But
okay, so we're talking about who is this individual that steps. I'm not a big follower of what
Annabelle Sciorra.
Annabelle
Sciorra. Look, if you watch The Sopranos, she was on The Sopranos. She was also in a movie with Sylvester Stallone called Copland. I don't know if you recall that one. It's where he played a deputy sheriff that lived in the suburbs of New York, where a lot of New York cops would live, and he was kind of looked down upon by the New York police officers as the guy who couldn't make the force, but good for you out here as a sheriff, and then he ends up having to investigate corruption. She was in that movie, and one of her allegations against Harvey Weinstein comes as a result of things that happened over at the Cannes Music Festival in France when she was there promoting Copland. And she says that she alleges Weinstein engaged in some conduct. And, that was the testimony that she talked about happening in Cannes, and also as corroboration for a pattern based upon conduct that occurred in New York. Weinstein can't be prosecuted for what happened in France, but it's being introduced to corroborate and show a pattern that corroborates what she alleged happened in New York that she is alleging was rape or sexual assault. So she testifies and says that that's what happened, and then the defense.
Did I miss it? You said it was around 1993, 94?
93, 94 along in there.
When she's claiming this occurred.
Yes.
Okay, so her testimony is very interesting.
Yeah,
and we don't want to get in detail because we're still keeping this PG, okay? And so don't talk about the details, but it's very interesting what happened that she's claiming. Remember, Weinstein is innocent until proven guilty, ladies and gentlemen, but this is her allegations. And what we're going to do is we're going to jump on what defense does to cross-examine her. And by the way, this is a little thing, and Todd and I know this as lawyers, the person cross-examining her is another woman. And and they do that a lot of times on purpose, because how would it look if a man was cross-examining this woman who seemed to have gone through a lot in dealing with this very powerful man, Mr. Weinstein, who was a producer throughout Hollywood.
If you recall last year during the Justice Kavanaugh confirmation hearing, the Republicans actually had a female prosecutor come in to question the accuser because the optic was better.
And we're going to talk about that, though, later.
Right after that, Weinstein brought a woman on his defense team for that purpose.
Yeah. But there's some interesting things that she's talking about, and we're going to bring that up when we're back from the break. We got the bottom of the hour news coming. Call us at 855-LAW-RADIO or tweet us at Radio Law Talk and get involved.
Radio Law Talk. Now, back to the show.
So we're talking about the Weinstein case, and one of this great, famous Sopranos actress is testifying, and what they do is they bring in people that testify of prior bad acts, and she's one of the witnesses of the bad acts.
Yes, so none of her testimony is going toward, and I may have misspoken when I was setting this up earlier, none of her testimony is going to the actual events that Weinstein is charged with.
Right.
This is to come in. Normally in a case, you're not allowed to bring in prior bad actions to say, well, if he did it then, he probably did it now, right? If you do a DUI trial, the jury doesn't hear about the defendant's prior DUIs, if they're alleged, until after they have determined whether or not the person's guilty on this current DUI. Then afterwards, they can find out about it if they have to prove the priors. But so normally that doesn't come in unless the prosecution can say, look, this guy's got a pattern. He's predatory. He does this and this and this, and he does it all the time. And that's what these four people, and yesterday and this week was the first, are testifying to about what he does and how he does it. And as Fred said, we're not going to get into the specifics. We'll just say generally what she's alleging is that in late 93, early 94, and the defense hammered on the fact that she couldn't be specific as to the date, that she had gone to an industry dinner with Weinstein. Weinstein gave her a ride home. And when he gave her the ride home, he forced his way into her apartment.
This is the allegation.
This is the allegation. Forced his way into her apartment and sexually assaulted her.
Yeah. So we can get on a few details that he was forcing himself and pushing her down, and she said she was punching him and kicking him to get off. He forced her to do some things, and she basically at a point she says, my body just shut down and I just just gave in, and I just didn't, and that's kind of her mantra. This is what she said.
That's what she said. And look, the defense is going to point out, and they did a little bit in some of the cross-examination. The defense is going to point out, one, though Harvey Weinstein, though there is a size disparity, defense is going to point out that your allegation is with one hand, he held your two hands over your head and then was able to do everything else, disrobe himself and engage in all that conduct. But with one hand, he held your hands over your head. That's going to be, open to interpretation as to whether or not he could have accomplished that with just the one hand.
And this is the cross-examination of Weinstein's lawyer, who was a woman.
Yes.
Bringing this across to her. Now let's make sure. There's 8 separate things. I'm not trying to interrupt you.
Sure, go ahead.
Let's make sure we hit all 8. So the first one they argue is you don't remember the date. Not only the month, you might not even remember the year. Sometime in 93, 94, late 93, early 94.
And she tried to come back and say, no. I remember it was late 93, early 94. Which kind of proves the point is, but you can't mention the specific date.
Right.
Which let me tell you something. This is why that's big.
Right.
Because if you had gone to an industry function in 93, 94, it ought to be pretty easy if you can remember the function that you went to go back and find out what date it was.
Yes, and by the way, we're going to lay out, again, these are allegations back at her, but there's going to be a psychiatrist that's going to testify. We're going to talk about in a minute. But here's important. The second thing she couldn't remember is the address of the building that she lived at.
Yeah.
She didn't remember that.
Which would be very easy to get in a credit report.
So that's another thing. And then also they argue, you were drinking a lot, weren't you, that night? And she said, no, I had one glass of wine. And this is on the cross-examination. They also said, isn't it true you sued your landlord? Your landlord sued you for $360,000. Don't forget, this is all going to her veracity, or her ability to tell the truth or remember things. And again, this is just going to Weinstein also, what type of person he is. So they bring up this landlord issue where the landlord sued her for $360,000 in major damage that she caused to this landlord's home, and they're arguing that she concealed this in this lawsuit. I mean, concealed this damage apparently to the landlord.
Yes, but she did admit, she conceded there that, yes, this happened. On the drinking thing, the issue they also brought up, because she was trying to say, I only had one glass of wine, and they said, well, weren't you on a film where your drinking was also brought up as an issue in your performance on the film? And that had to come up too. Right. The next area where they get to, the next area that the defense gets to is how she reacted immediately following this claim that she was raped by Weinstein. And this is where the defense really needs to be careful.
That's exactly right, because they actually have experts, the prosecutor does, coming in testifying what happens to rape victims and how they react. Because,
exactly.
First of all, they all react differently, and just because you don't act like a normal, quote, normal person would act is not necessarily mean that you were not raped.
You've heard me say, I said this last week, and I've said this all the time as a prosecutor for 3 years when I was prosecuting these cases, and this isn't the type of case that I will handle as a defense attorney, but there are as many different ways for somebody to react to being raped or being a victim of sexual assault as there are victims of sexual assault. There is no normal.
Right, that's exactly right. So here's the cross-examination.
Yes.
We're still in the cross-examination. Quote, when you woke up, did you go to the police?
No.
Her answer is no. And next question, when you woke up, did you go to the doctor?
No.
When you woke up, did you go to the hospital?
No.
And here's another interesting thing. At the time, okay, let's back. Well, there's a couple of things. And she basically said, I just went through my life and pretended it never happened because I wanted to get back to my life. I resumed my life to the best of my ability. That's her argument. Remember also, by the way, we got to put ourselves back in that time period. Weinstein was a very powerful producer. And I'm not, again, we're staying neutral, but you've got to take all this into consideration. Does she go out and say something about it or not? Also, because she said she didn't call the police because he was someone I knew, and she actually thought kindly of him and that he was a good person. And this kind of threw her for a loop. Now, here's the other interesting thing. And then she argues at another event, he tries to kind of make some passes at her too. And at the time, she was good friends with apparently Sylvester Stallone. And
she was in the movie Copland with Stallone.
Stallone and who's
Bob De Niro.
De Niro,
yes.
Robert De Niro. And they said, why didn't you go to Stallone and De Niro? I mean, they're there. They're your friends. Why don't you go to them and say, I have an issue here. Why? Please help me with Harvey. And she basically said, well, I didn't. But then, we're going to get into this in a little bit, but about the psyche of a person who's been raped or been molested.
There was one other thing that she said here when asked, because she was asked about whether or not she felt that she had been raped at the time. And initially she said no, that she did not feel like she had been raped. And her quote was, I would say at the time that I felt rape was something that happened in a back alley in a dark place by somebody you didn't know,
right,
holding a gun to your head. Now, I don't know if the defense is going to raise this or not, but that's an interesting thing to say about an incident in 93 and 94, because if you remember, there was a very, very high-profile sexual assault case. It was one of the first ones that was on TV. It was the William Kennedy Smith trial that happened down at Ted Kennedy's compound in Florida.
Right.
And that was all about a date gone wrong. It was very similar to all this. And I think the defense would maybe counter, well, wait a second, that might be true in 83 or 84, but by 93 or 94, there's a lot of public information and a lot of publicity about this kind of conduct that happened because of William Kennedy Smith, and that might cut against the idea that she thought it was this type of conduct. However, you can never get in somebody's mind and tell them what they are or not thinking, can you?
Yeah, no, so there's all this. The thing you always have to be careful of in these type of cases is hindsight's 20/20.
Yes.
She should have done this. She should have done that. And again, this is back early on when it was a little bit different. I hate to say it. There was not the Me Too movement, and she was probably scared of what he could have done. When we come back, we're going to talk about the expert psychologist testifies about myths concerning individuals that were assaulted either sexually or raped.
Radio Law Talk. Now back to the show.
So Barbara Ziv is is an expert in psychology dealing with rape victims, and she is on the stand testifying on behalf of the prosecutors as to what typical rape victims, and everyone's different, go through. And this is very interesting to read because this kind of follows in line what the witnesses are saying also. She first says that there's myths. Number one, and there's an incorrect belief that most rapes are committed by strangers of the victims, and that they generally resist their assailants. That's a myth, she testifies. And by the way, how is this individual psychologist known so well for? She testified for the prosecution in the Cosby case. She said also the vast majority of sexual assault victims don't promptly report what happened to them. Also, usually they don't always reveal their claim or remember exact details of the incident. And a lot of people, she states, believe that are victims of assault, that they can put this behind them and try to move on. As devastating as it is, they're going to just try to move on. I could see that also, especially if you're, this is back in the 80s, 90s, and there's a powerful person that's in the industry that you don't want to affect your acting.
When you think
jobs.
you have no recourse,
right?
What else can you do?
Right. But the other, and the reason they're doing this too, by the way, defense is just starting. There's all types of friendly and even loving messages back and forth between the defendant the defendant in this case, and the person that's claiming that they were assaulted. Again, I can't remember the Sopranos lady we just talked about. She's just a cooperating. She's not. This is not about her. It's about this other individual.
One thing to keep in mind is that when people face a traumatic incident, regardless of what it is, there are one of two common ways that they respond. It's called fight or flight. And oftentimes, you don't know which one. You can say that you are one or the other. You don't really know which one you are until you find yourself in a situation where your response is one of those two type responses. And look, if you've gone to dinner and the person has walked you to your door and you're done and they're an industry professional and you think that they're really great, and then all of a sudden this is happening to you, I think it's perfectly reasonable that maybe the flight, or I would say the paralyzed, your mind goes somewhere else response would kick in. You can't say that that's not normal. There is no normal, but not all people are going to fight.
Yeah, no, and they all act differently.
Yes.
And so one of obviously the big argument of you didn't go to the police, you didn't call anyone, you didn't call Stallone, you didn't say to De Niro, you didn't talk to anyone, you didn't go to the doctor, but this expert is testifying, is going to say, or basically said that that's not unusual, that they don't do that. Now, there's going to be battling experts. There's going to be experts you watch on the defense side. They're going to come up and say the opposite.
Seems like being a victim of a mass shooting, and the hotel attorney says, well, how come you didn't run? How come you didn't hide? Yeah. How come you didn't do this? How come you're just second-guessing behavior that's not second-guessable? I don't.
Right. So anyway, we're going to move on from that because we got a million things to talk about. But they also cross-examined this expert. That's the defense of Harvey Weinstein, saying she's a blind expert. What's a blind expert? A blind expert is one basically that's not going to talk about this case. They're just talking about generalities, and they go into how much money the state has paid her, and quite a bit of money to come in and testify. So that's coming up. Then the final witness is, and we're not going to get into detail of this, is a former board member of Harvey's in his company who, this is one I you take this with a grain of salt. They didn't like each other. One person took another person's job. You took a movie that I should have had, type of thing. And they separate ways. Of course, he's got a bone to pick. I don't know that I put a lot of credence into that. Who knows what's going to happen? But another interesting thing, though, is about something I didn't know is the prosecution. What is their decision to show jurors a photo of the Weinstein with former President Bill Clinton in their opening statement, and they said you should throw this whole case out. That's something I didn't know, but they're.
Go to the website radiolawtalk.com. That's radiolawtalk.com.